Dear all, good afternoon or good morning, depending on where you are. My name is Olena Perepelinska, and in my capacity as a president of Ukrainian Arbitration Association, I am very glad to welcome you here and to open this first arbitration conference of the Ukrainian Arbitration Association. Ukrainian Arbitration Association was created in the end of 2012. And within its very first year of activity, we discussed the idea to organize a big arbitration conference. However, the revolution and subsequent events in Ukraine and Kiev precluded us from doing it then and made Kiev and Ukraine in general not the best place for offline events for several years. Later on, as a young organization, we also had limited resources, especially human resources, to carry out ambitious projects in parallel, so we decided to focus on other activities of Ukrainian Arbitration Association. And when finally we decided that it's the right time to organize a big event and even started preparations, COVID spoiled all our plans. However, we had to rethink the concept, we had to accept the new reality, and now, thanks to COVID, we have an opportunity to host this online event and to welcome participants from different parts of the world, including those who have never been in Kiev and who most probably would not have attended the offline event in Kiev even in the pre-COVID times. And that's great. So the distance, logistic issues, and difference in time is not an obstacle anymore. And we decided to make our conference as international as possible, including in terms of language, program, lineup of speakers, and even time slots. And you could find all the details of our program at arbitration.kiev.ua. And just a few remarks about the format and the program. We are going to organize a networking session after the second panel today. With this network, and to try to structure our discussion, so there would be 7 different virtual rooms, and you would be able to join them. However, that would be a free discussion, exchange of ideas, sharing experience, so anything you would like to take part in, you are welcome. So we invite you to join our discussion of the topical issues which are equally relevant to all jurisdictions, and hope that you will find the answers. And with this, I would like to conclude my opening remarks and to invite our first panel, which is going to discuss the issue of access to arbitration. The session will be moderated by Anna Gyar-Sashko, board member of the Ukrainian Arbitration Association and associated of Paris office of Sherman Sterling. Anna, the screen is yours.
Thank you, Elena. Good afternoon, good evening, everybody, or even maybe good morning. Thank you for joining the first panel of the first annual conference of the Ukrainian Arbitration Association. My name is Anna Gyar-Sashko. As Olena already said, I'm a board member of the Ukrainian Arbitration Association. I'm also a co-founder of Nash Arbitrage, one of the partners of this event. I have an honor to moderate today a panel with distinguished speakers. Today with Svetlana Romanova. Svetlana is based in Kiev. Also today with us, Maria Hauser-Morel, Dr. Maria Hauser-Morel. Maria is a counsel at Hennefeld and is based in Paris. Our next speaker is Professor Ziya Akinci. Ziya is a founding partner at Akinci Law Office and also president of Istanbul Arbitration Center. Ziya is based in Istanbul. I'm also delighted to introduce our fourth speaker, Rytis Valunis. Rytis is the Chief Administrative Officer and General Counsel at KN and also a board member at Baltpool. Rytis joins us from Vilnius. By the way, you can find more information on our speakers in the conference brochure. Today, the topic of our discussion is access to arbitration. From one side, this topic is widely discussed, and in the recent years, we have witnessed a number of initiatives undertaken by different actors aiming to facilitate access to arbitration and make arbitration more efficient. On the other side, many issues remain unresolved. Today, there will not be formal presentations, we will just discuss different questions, and our speakers, experienced arbitration users, will share their views and insights. At the end, we will have time for questions, so I encourage you to add your questions and comments to the commentary box on YouTube. Now let's turn to the first question. As our speakers have different background, had different experience with arbitration, my first question is, what is the first thought that comes on your mind on hearing access to arbitration? Maria, would you like to start the discussion?
Yes, of course. And thank you very much. I'm happy to be on this panel. To me, access to arbitration should be put in a larger context of access to justice. And of course, the first aspect of access to arbitration is the actual right to bring arbitration proceedings based on an arbitration agreement. But access to justice also means that once you start arbitration, it will actually lead to an enforceable award, and the actual process will be fair and efficient and led by an independent and impartial tribunal. And it's helpful to see that even on the arbitration ground, principles established by the European Court of Human Rights with respect to the access to state courts, including independent judiciary, fair process, and so forth, will be relevant in the context of arbitration. So not only the right to begin arbitration, but actually so that the whole process brings real justice.
Thank you, Maria. Zia, would you like to share your view?
Thank you for the invitation, first of all. I'm very happy to be with you, even through virtual program, but I'm really looking forward to be in Ukraine again. And when I hear access to arbitration, Maria very wisely summarized, it reminds me two things. First, being able to take your case to arbitration, and that is very important. That involves cost and also involves positive, constructive interpretation of arbitration agreement. But also the second interpretation, as Maria correctly stated, is access to justice. And if I have only one word to describe access to justice in arbitration, I think impartiality, independence and impartiality of the arbitrator is very important. Thank you.
Thank you, Zia. Svetlana, what about you?
For me, the very first thought which comes to my mind when I think about access is obviously getting an end result and getting it efficiently from the standpoint of costs, from the standpoint of time, and from the standpoint of effort which you put in actually getting that result. So I look from the result backwards to the beginning. So if I don't have a result in the end, there is no point in getting into the process, and the access in that particular case doesn't make any sense. So result is what is important, efficiency of reaching the result.
If I can just ask a follow-up question, of course, that covers enforcement, not only up until the award, but until you get the money.
Absolutely. Yeah. From the business, obviously, the businessman, our commercial people, our clients, internal clients, we as in-house lawyers, we're working with them. They don't care about the process. They care about result. They care about when they get money. They care about when they ought to pay money if we're the debtor. So, and that is only possible when we get to the very end, including the enforcement.
Thank you, Svetlana. Ritis, what about you?
Indeed. First of all, thank you very much for inviting me and having a chance and opportunity and access to this distinguished panel today. So it's a big, big pleasure. And now going on and be actually building on what was said already, I can only concur from business perspective, representing an energy infrastructure company and representing the in-house lawyers cohort today. I can only concur and maybe emphasize that to me, the access to arbitration means, first of all, efficient, of course, the ability to bring the claim, but then the efficient, impartial process, which results in a flawless, free of errors, any other deficiencies, enforceable award. And that's basically the great or qualitative access to arbitration from business perspective. And from the client's perspective, who are actually the ultimate payers of all the bills that come out as a result of arbitration.
And what challenges do you face as a company in accessing arbitration or using arbitration, Ritis?
First of all, I can think of quite a few not related with each other moments or circumstances. So the first thing is probably the jurisdiction itself, because if you do a global business, and for instance, we have a company and business in Brazil, which is involved in infrastructure business, then the question, the question of starting point of question is basically, can you have all those features in that particular jurisdiction? And not only the process efficiency and so on, but also the enforceability of the award. So, and that way you can assess your accessibility as such. So that's first thing, the jurisdiction and the interacting jurisdiction where you do actual business. Then efficiency element. So is the institution or the basically the forum where you agree to delegate your arbitration is efficient? Does it have efficient procedures and is also able to, let's say, to gather all together, organize the setup, and also have a experienced and not very busy or extremely busy arbitrators and all necessary personnel to organize the arbitration procedures efficiently. And probably the third thing, it goes down to the expenses and the money aspect of the access. So basically, how much does it cost to start arbitration, to run the process, and arrive at the enforceable decision and award? So this does also matter because for the smaller amounts of, let's say, possible claims and contracts, you don't, the expensive arbitrations and the prominent institutions might not be accessible from the business case point of view, meaning that you may not be capable to actually get the financing or from the CEO to go into that case and hire competent lawyers.
Well, but can I add, because this is the job for a lawyer to do at the stage of concluding the contract. Mm-hmm. So you don't think about it when you go to the arbitration. You think about it when you conclude the contract. And this is where and when you make that choice. So.
Indeed. Well, the reality is that usually I've been examined and scrutinized process in the commercial agreements because the companies, the partners, businesses don't care much about the litigation clauses and dispute settlement clauses, and it's always about the commercial provisions, the prices, the terms, obligations, and so on and so on. So it does really depend on the smartfulness of lawyers involved in the making of the contract. So I would say if you have good lawyers, you would always pay attention and you would always take care, even though your CEO or the board don't care about it. So I don't know if I managed to answer your question, but that's rather the.
I mean, it's your experience.
That's my experience.
Yes. Svetlana, what about you? What are your challenges?
Well, my only challenge is to be wise enough and visionary enough to predict how a particular contract will end up in the end, whether we will have a dispute, we will not have a dispute, what kind of possible claims we might face, whether those claims are worthy of litigating or arbitrating, and if the choice is in support of arbitration, then which tribunal we go, which institution we use, and so on and so forth. I think this is the hardest part, and that is the job we should do as the lawyers. And if you're a good lawyer, you can do that prediction, and then you don't have any challenges in actually getting your case arbitrated and getting a successful result in terms of cost and time and efficiency. So that's where it starts.
Okay, thank you, Svetlana. So we've heard about business perspectives. Now let's turn to institutions. I think many of our audience know that Maria worked as a counsel at the ICC for many years, so she's quite experienced. We cannot say a representative of an institution, but know how it works. And Zia is the president of the Istanbul Arbitration Center. Facilitating access to arbitration and facilitating providing access to arbitration.
Thank you, Anna. My connection sometimes suspends, so but I think I got the role of institutions, you mean, right?
Yes.
Yeah, sorry, there was a little blank. Yes, indeed, I do think that institutions have a role also to increase predictability that Svetlana mentioned. So the institutions are there to ensure access to arbitration in a way that they will clarify how to get there and what's the procedure in order to start arbitration and in order to run an arbitration proceedings. That means that the institution should be available for answering any questions that the parties may have, but also ensuring that arbitrators are independent and impartial, a point that we mentioned in the beginning. And as many of you know, for instance, ICC has a very strict and thorough process whereby the institution makes sure that the arbitrators who are put in place are independent and remain impartial. The institution may also put in place a case management that will ensure that the arbitration process, is actually efficient and fair to both parties. That requires, of course, that somebody will follow up on the case all the time, as it is done at the ICC. And another point, going back to predictability, is publications. And here, for instance, ICC, but also other institutions regularly publish information about statistics, but also excerpts from procedural decisions. And soon ICC will publish awards. And that will go to the predictability in terms of, if I start an arbitration, what are the chances? I think there will be more examples out there in the air. And I think for the users, the predictability will increase with of awards. And just to add that in addition to institutions, I think associations such as Ukrainian Arbitration Association do have a role with respect to access to arbitration by talking about arbitration, making these rules more clear for the users, and making arbitration more friendly. So I think it's not only institutions, but also local associations, because to make sure that arbitration is understood locally and takes into account local specificities. So that will be my long answer to your short question, Anna.
Thank you, Maria. It's very interesting and insightful, and I really looking forward to read the awards, the new awards. Zia, would you like to add something?
Yes, I think the arbitration institutes play an important role to access the justice in arbitration. First of all, transparency is important because not all the parties are experienced in arbitration, so they should know the practice of the institute to the extent possible. There may be a secretariat guide or some explanation, so that makes arbitration transparent and predictable for the users. Also, appointment of arbitrator is very important because our expectation is the arbitrator should be independent and also available. So the institute make sure that the arbitrator will be available and independent for this particular case. Also, in practice, the institute should be responsive when the parties ask any question, make any application. There should be a reasonably fast answer to the users, to the parties. Sometimes, unfortunately, I experience as a party representative, I called some of the institutes, and I mean, there was no response to the phone. Practically, the phone rings, but there is nobody to respond. Or you write letters and you don't get any answer. Or you write, you say, when can we ask very polite whenever it is ready, etc. So these are really very concerning for the parties, because if you don't know the institute and then if you get this kind of reaction, how can be sure that you are going to get justice in arbitration? Also, one should not forget small claims are also important. Institute has a significant role to survive the small claims. Therefore, the institute can offer fast-track arbitration or specially designed arbitration for the small claims, because an amount may be small for one party, but for the other party, this amount may be very important. So you cannot simply ignore that, oh, comparing to the other giant arbitration, this amount is small. I think one should not ignore small claims as well as an arbitration institute. Thank you.
Thank you, Zia. That's true that one of the impediment to access to arbitration is its cost. And my question goes in continuation of the discussion, of course. In terms of justice, sometimes we deal with complex arbitrations, sometimes with more straightforward arbitration, and different cases have different amount at stake. What are the criteria? What do you think? Where should be a line between litigation and arbitration in terms of access to justice? Ritis?
That's millions, and I see plural, millions euros or dollars question. And I believe that there is no single correct answer to that. Having said that, from my company's perspective, we basically want to have arbitration when we have, and that's usually as the case, the investment and infrastructure projects that exceed several million euros. So double digit, that's probably the threshold to think about arbitration. And with that in mind, we normally, depending on our partners and their origin and state of origin, the recent practice was that we would trust the Stockholm Court of arbitration as a convenient forum and the one with good reputation and track record. So this is the first threshold. That's one thing. And then depending on the arbitration clause and whether you can basically receive and use the expedited procedures. In some cases, that the threshold was even lower. So I can think of, I don't know, few million possibility to arbitrate. But normally what happens when you have a small claim, let's say a few millions, parties are sort of reluctant to go and incur all the expenses, and there is more motivation to negotiate and settle differences amicably. So that is my takeaway. Otherwise, then again, a layer is the jurisdiction of your partner, and basically, if you do business in different jurisdiction, it is a default rule to choose the arbitration provisions, the dispute settlement, delegated arbitration as a rule, because you may not trust the national courts because A, you are not experienced with national, let's say, case law of the Brazil. B, you still want to have some sort of control over the dispute by using your rights in arbitration. That's the appointment of arbitrator, and then have a certainty and clarity when it comes to organizational provisions, how the dispute is handled. So I think these are two very important aspects that we consider. But there is no. So every time you look at it as an on ad hoc basis. So you have a contract, if you have. But I mentioned that normally business and boards tend to ignore, don't care. So be sure that you have smart and experienced lawyers so that they care of those provisions, because sometimes this bad word happens in reality.
Okay, so the lawyers are very important, and smart lawyers are even more important.
Indeed.
Svetlana, how does it work for you?
Well, for me, first of all, we tease ourselves with the fact that lawyers are important, but not the lawyers are important, but business people are at the top of the hierarchy. And as our clients, they play the tune and they order the music. And upon their appetite for risk and upon their expectations, could provide, and also obviously I'm not saying that we should please them in all respects, but we should hear our clients and try to understand and predict how the situation might evolve and in which position we might end up, in a position of a defendant, or most likely will be in a position of a claimant. But I generally agree with Rytis. Each case is a particular case. You look at the situation and then you do the predictions, and this is where you make your choice which way to go. Obviously, all of us know about the alternative. Everybody's have a choice, or they go even a more complicated way and say, okay, claims above that amount go to arbitration. If claim is less than to litigation, but this is again not a magic wand in a way, because you need to be careful with these types of clauses, and this is where you need good lawyers. That's absolutely agree on that, to draft those clauses properly and then not to have a conflicting situation where you disagree on the forum, and you are in a deadlock with the other party in terms of where you should go to resolve your disputes.
Thank you, Svetlana.
Anna, can I add?
Of course.
Short points. First, that small cases are not necessarily straightforward. And failing the party settlement, we should give them access to justice, whether it's litigation or arbitration. The trick is that this justice should not be too expensive, as it is said. So that is why, also arbitral tribunals, not only institutions by creating special procedure for claims below 2 or 3 million or whatever, not only institutions, but also arbitral tribunals should make sure that they do not treat each case in the same way. So you cannot have for a case for 1 million euros, 3 rounds of submissions, document production, and so on and so forth. And unfortunately, speaking from my experience at the ICC, some tribunals are tempted just to reproduce the same process in each case. So I think that the responsibility is not only on the smart lawyers, but also on smart arbitrators to make sure that the procedure is adapted to the complexity of the case, so that even in these small cases, for maybe not as much money as they would have spent otherwise, the parties can get justice. But that requires a lot of preparation. I think early preparation is from the tribunal, and maybe Zia, who's more experienced arbitrator than I, would say how beneficial it is for arbitrator to be at the desk early on and know the case early on in order for the procedure to be adapted to the needs of the case. And that may require, for instance, the solution may be in a small case that the tribunal early on provides a preliminary review on the case and then the parties settle. But the tribunal should have an open mind and think about how to best render justice to the parties.
Thank you, Maria. Zia, would you like to add something from arbitrator's perspective or the counsel perspective?
Yes, I would like to. I mean, I echo all the arguments that my fellow panelists already expressed, but I just would like to make point. It is not exactly possible to predict whether the case is going to be small or big. You may have a big contract, but at the end you can have a small dispute, or you can have a reasonably small contract, but you may ask loss of profit for 10 years, then suddenly you can have a reasonably big contract. So therefore, I think arbitration industry should offer flexibility to the parties. And also in some cases, even if the amount is small, arbitration may be the only efficient way to resolve the dispute because of neutrality, because of enforceability, etc. So at the end of the day, the parties may need arbitration, may need to access to arbitration. So therefore, as my fellow panelists already expressed, the arbitrators as well as the parties should be flexible to adopt their case into the amount of the dispute, if necessary, save the cost as much as possible. And the rules of the institutes already allow this instead of three-panel arbitrator, instead of hearings, maybe even without hearing. So I think as practitioner, we need to be very flexible and reasonable to give the parties the right to access arbitration. Thank you.
Thank you, Zia. Maybe somebody would like to share an example when they preferred arbitration, but then they were disappointed and then thought maybe we should choose the litigation, or vice versa.
If I may start, in our arbitration community, let's be honest, we arbitrate and we love it. But in all our conferences, we talk about challenges of arbitration. And then maybe without any intention, we give the impression to people that arbitration has so many disadvantages, etc. So therefore, I jumped to this question. I would like to start the advantages of arbitration. Sometimes we have clients who have project and dispute in very difficult part of the world. And when we interview them, without any merit, the first question we ask is, do you have an arbitration clause in your contract? Because if there isn't, and if the national courts has jurisdiction in this dispute, I mean, we say, I'm sorry, but it is so challenging. We cannot help you and we cannot expect a reasonable decision, especially if the dispute is against a state or state party, etc. In many of the big project, construction project, that is the case. So therefore, I think we should promote arbitration as well as talking about the challenges. So therefore, my first expression is in many cases, I felt that, oh, thanks God, there is an arbitration clause. And then I started to listen to the client because it was possible to help to the client that there was a arbitration clause. But the other side of the coin, yes, I think we all have experience, including myself. Sometimes I say, if this was a litigation instead of arbitration, the cost would be much less, and then we wouldn't have very long hearing with so many witnesses, etc. So the court would resolve this issue easily, maybe faster and less expensive. But this is very minority. In many cases, I am very grateful that there is an arbitration clause. Thank you.
Thank you, Dia. Svetlana, Ritis,
Maybe I
Maria?
can. I just briefly, I think for interim measures already, state courts may, in many jurisdictions, be a much more efficient way to get where you want. And sometimes just by having a successful application for interim measures, you can then settle the dispute on the merit. So I think the decision as to, sometimes you may want to go to state courts because they may be very efficient for a particular type of dispute.
Well, from my end, I may say that in my practice there have been cases where we challenged the existing arbitration clause, and we applied to the state courts, hoping that the other party would not object before starting the hearing on the merits. And there have been cases when the lawyers on the other side somehow did not do it, and then found themselves in the situations where they actually gave up the arbitration clause, and we actually, achieved what we wanted. So it's part of the strategy. And yes, we do find ourselves sometimes in the situation where we wished we had a different clause. Arbitration instead of litigation, or vice versa. And then if it was an arbitration clause, I say that there is a way to overcome it if the other party is not quick enough and witty enough. It's harder to do the other way around, obviously, because you need a specific consent of the other side to go to the arbitration instead of litigation. And those types of cases, I don't think I have anything at mind to share right now, but I think we made an attempt to specifically agree and to change the litigation clause to replace it with arbitration at some point. I don't think it was a successful one, but doesn't happen that way too often. I don't know, Ritis, maybe you have a different practice.
Well, gladly, I don't have a bad stories with the happy end, not with a happy ending at the very end. However, I can say that the situations we use this term in basically daily activities, the near miss, when something when something nearly happens bad, but it ends up not happening. But then you can learn some lessons from that event. So I would say that now reflecting back, I can think of, let's say, moments in the arbitration cases when you have a bad feeling or the bad impression that things don't go the right way. So what I have in mind, for instance, the appointment of arbitrators, and well, in case of institutions, so you receive the message about the appointment, then you check the profile, the background, and then you develop some bad feelings about the expertise, the competence of that particular arbitrator, and you're not sure if you will get the justice, let's call it, delivered, then again impartially and appropriately, and so on, so on. So that's one thing. Sometimes the competence. Sometimes it's about the speed of communication. Then again, if some procedures get delayed, and sometimes it's on the contrary. Actually, I have much better impressions and experiences than worse impressions, where you have the attempt to abuse the procedural rights by opposing party, and then you have a kick or punch by the institution and the chair to that party to speed up and actually to have the award rendered within reasonable time. So I would say that no clear answers or misbehaviors of the arbitration as such. But then again, we are all human beings, so sometimes you expect, maybe you have higher expectations. Sometimes those expectations are not met in some stages. But then if you have the award rendered, issued, and it's fully enforceable, and the best thing is to have an award rendered which is enforced or met, complied with by the by the opposing party without need to go to national courts and enforce it. So that's the sign of the quality of the process, the award in itself, and maybe the reputation of the institution and the tribunal. So this is my maybe a little bit vague reflection, but that's the way it goes. And maybe I can add on the top that my experience is that when you do business and you have a new partners coming to Lithuania, in this case, because I live in Lithuania, or you go abroad, normally the default presumption is lack of trust. You don't trust national local courts because you're not familiar with the environment. If you spend more time doing business and doing business in that particular jurisdiction and vice versa, I think businesses, they develop this trust, and that way they tend to trust the local courts more, and then maybe delegate or redraft, basically reschedule, redelegate some of those potential disputes if they arise to national courts. So this is my impression, but this is familiarity, maybe this aspect. The more we are familiar with something, the more we trust something. This is a psychological human nature effect, I think.
Thank you, Rytis. I think also what is important is also transparency of court decision on the enforcement and setting aside of the award in a specific jurisdiction. And today we will have a special presentation on the analysis of statistics in Ukraine. And I know that different countries, different initiatives, we can see now just to promote the enforcement and promote their countries, they conduct this analysis.
I think it's a very good point, Anna, because I think it's just to say that access to arbitration, you cannot have a full access to arbitration without the support of state courts. So I think the point that you made about the pro-arbitration state courts, I think it's a very valid point.
My next question is about access to arbitration, but from another perspective. We all know that now there are more and more LLMs on arbitration. There are more and more law firms, lawyers wanting to practice arbitration, and the environment is very rich and varied. And this question goes to Svetlana and Rytis. What criteria are important for you while choosing a law firm to represent your company in the arbitration proceedings?
Rytis, do you want to go first?
That's the biggest secret. Of course, I can go first. I think I can start from a different, from the opposite side, and deny all the stereotypes that it's all about the competence. Of course, the track record, the academic works, and the possibility to check your lawyer's competence, the ratings, rankings, international, different those indexes and so on. So this is really important. And again, the quote, something big and so sparkling. I'm just joking a little bit, but I think what is really important is the trust established and developed in course of your work. And normally you choose the law firm which ideally which you do business with on a daily basis for commercial transactions, for M&A, for any other kind of activities. And then if you end up in a dispute, that would be the first point of contact to go. So provided that they have the arbitration or dispute settlement or litigation division in the law firm. So that's first point to consider. It's really a human nature, again, a trust. And then I wouldn't be probably, and it wouldn't be unfair to say that, guys, the arbitration, it's the world of the community. So it's the insiders community separated from the rest of the world. And like a secret club, someone see people, this is mafia. And of course, it's when it comes to the decision what to choose, who to choose, and so on, you always think about who you know, whom you met, whom you hear. So these conferences, they play a great role in helping to make new connections, getting to know people, and then choosing the best professionals, because I'm certain that this conference attracts the best people in their respective fields. So this is a little bit of pleasing maybe and sweetening, but that's the way to go. You look for someone whom you can trust and whom you know.
Thank you, Rytis. And you also said earlier today that usually as the seat of arbitration, you go to Stockholm. Do you have a similar choice for arbitration? You prefer to work with the law firms, I don't know, from the UK or France or Switzerland?
So it's always about, I think the chosen law is important. And in my company's case, in the energy business, for some reasons, and shipping business, the default applicable law is England and Wales law. And that way you need someone who is knowledgeable. That greatly limits the possible choices. And of course we look...
And increases the cost.
And increases the cost, correct. And since you mentioned, I remember I was in a conference exactly 10 years ago in New York, arbitration conference, and the New York lawyers were talking about the expense of arbitration, and they were saying, well, the clients and people accuse us of being aggressive lawyers and arbitrators. They are much more expensive than us, so it's not fair. So I would say, of course, money matters. But then again, I would say that, I am a millennial already, so you have this natural tendency to work with people from your generation, I guess, and it's becoming. And of course, the diverse team are really important. So from my point of view, I tend to look for law firms and lawyers who are rising stars, and not only the matured stars, because I believe that the diverse teams composed of both rising stars and then really experienced lawyers, matured lawyers, proven lawyers, that way you can really get the energy, the necessary dynamism, the experience, the know-how, but also this maybe the hunger to win and hunger to do everything that's up to you and maybe go this extra mile. So I trust in the companies and law firms that I diverse, and they have lawyers who are growing, who are becoming and they are already rising stars and really determined, and someone with really track record proven experience, but maybe to act more in this advisory coaching role and so on, are really, really high. I can assure that if you have only superstars, this is the best way to spend all the the external lawyers' budget in the company.
Thank you for your honest answer. Svetlana, what about you?
Well, I'm sitting, I was here in Ritis and I was thinking about, it's like, okay, Ritis is a millennial, so I feel old. Anyway,
no offense, it's just a joke.
no, I'm just kidding. Forever young and forever energetic. So for me, the choice of a law firm is, again, it's always a subject of an analysis in each particular case. And our company, we do not have a pre-selected panel. We don't have any preset preferences. We're normally opened to any choice we might have and we might get in each particular case. And how we do the choice. First of all, for me, there is a high importance is placed at a correlation between the case, its value, complexity, jurisdiction, forum where it is going to be resolved, and the law firm which we entrust with this case. Because if it's a small claim, if it's a simple claim, I don't think a magic circle law firm is necessary. Yeah, I can do it much more efficiently with going down the tier. If vice versa, it's a complex case, multiple parties. Obviously, you need the best legal support you can get for your money, and this is where I look only at the magic circle. So this way of thinking provides me with a variety of law firms which I'm working with in each particular case. And it's true to say that we work with big law firms, with stars and known personalities in their fields, and with the smaller law firms, local law firms, which can provide us with a tailored, very local advice we need in each particular case. If correlation analysis is done properly, then the cost is proper. The quality should be for the cost should be acceptable. The efficiency of the process, I think, would be also on a proper level. So that's how we go about it.
Thank you, Svetlana. I'm curious to know, how do you see the changes in Ukrainian market? How it changed in the last, 5-7 years for you?
In respect of, well, there are lots of changes in Ukraine generally.
Because I know, traditionally, for many years, not only in Ukraine, in many countries, for big cases, you have a leading counsel, international law firm, and a local counsel. And I understand that now there are more and more businesses using local law firms without just maybe as an external consultant for very limited questions. But otherwise, there is this move to use more local law firms than international.
Again, speaking from my own experience, and this is where I completely agree with Ritis, you need to work with the person you trust. So normally then talking about Ukraine and about local law firms, law firms in Ukraine, not local, but law firms in Ukraine. I do not, my way of thinking is not to think about a law firm. I think about a particular personality. I think about a particular lawyer I want to work with, and it doesn't matter for me where that particular lawyer is employed at the moment, because lawyers tend to change and to shift between law firms. I'm looking at a particular specialist, at a particular lawyer whom I can trust, who I feel comfortable with, and who I can call in the middle of the night if I need. Yeah. So for me, here in Ukraine, if I'm to choose a lawyer here in Ukraine, doesn't matter whether it's an arbitration or something else, I always go for a name, not for a law firm.
Okay.
Anna, can I have a brief follow-up comment on that, if we have time?
Sure, we have time.
I did notice that in the last years, about 10 years when I was at the ICC, more or less, parties from Eastern Europe 10 years ago were using much more Western firms because they trusted them as, as you said, there was this mafia. And I think right now in Central and Eastern Europe, you have so much more expertise, and you have local firms that have really a lot of expertise, quite comparable to the expertise from London and so forth. And so what we have seen more and more in Central and Eastern Europe is that you have a pairs of a local counsel and an external counsel, but I think more and more local counsel who are very experienced. So I think it's no longer the mafia that we used to have 10 or 15 years ago. I think this has really changed in Central and Eastern Europe. I think we can be proud of ourselves in this regard.
I can tell you that I'm using a local law firm and a particular partner of a particular local law firm for an international case right now. So that's happening as we speak.
This is great. I mean, like, I left Ukraine more than 10 years ago. I work with Ukraine. I go back to Ukraine very often. And it's like every 2-3 years, I see this very good improvement in arbitration and in like our community becoming stronger and stronger.
So Anna,
also
you should
in
come
terms
back
of language
then.
skills.
Yeah.
And also in terms of language skills, I think access to arbitration is possible if people speak English, because many arbitration cases are in English. And I think in Central and Eastern Europe, the English is now spoken matter.
My connection was bad. Okay, before we turn to the question from the audience, his first appointment or to develop his profile as an arbitrator, can you give a couple of advice?
Yeah, my connection was bad again, about how to get the first appointment, right? And
not the first, but to build as arbitrator. What is important? Is it important to be a speaker very often, to publish, I don't know, to write a PhD, to attend all the conferences in the region?
yes,
I'm joking.
I do not. Yes, I don't think writing a PhD is an enjoyable activity, but I don't think it brings cases. Speaking at conferences doesn't bring cases. Building relationships with people may bring potential appointments. At least that has been the case for me, because for arbitrator appointments, you need, like for counsel appointments, trust of people. Riti said Svetlana will not appoint somebody who they may have heard at a conference, who is a good speaker, but somebody who has a good reputation and knows how to read law and who understands business. And I think a good arbitrator as well needs to really, or potential arbitrator needs to not only be an expert in arbitration, but also understand business and economy. And I think many young people start to understand that, and they even study economy in addition to law, to have that business approach, not only the legalistic approach. So I would say that building a network of contacts is important. And then once you have your first case, work and be prepared, and really make sure that the quality that we've talked about that it's highest quality ever. So that these will be my initial reaction. That will be my initial thoughts. Yeah.
Thank you, Maria. Zia, what about you?
Of course, knowing arbitration is important, but also if you want to be an arbitrator, you need to be an expert in a substantive law, such as construction law, corporate law, transportation law, finance law. There should be an expert area that people would recognize your expertise and appoint you as an arbitrator. And this question is being asked me very often, because when we try to promote Istanbul Arbitration Center, many fellows ask, how can we be an arbitrator? And my humble advice to them is, they should draft arbitration clause in their contract as much as possible. That will enable them to attract more and more arbitration cases as an attorney, as a lawyer. And then when they are experienced in arbitration cases, sooner or later they are going to be appointed as an arbitration. So in fact, our colleagues' arbitration career is in their hand. The more arbitration clause they draft, and in more arbitration cases they act as an attorney, they will increase their chance to be an arbitration expert. Thank you.
Thank you, Zia. I also heard many stories of arbitrators who started their career like in the 90s, in 2000s, that for them becoming an arbitrator or starting practicing arbitration was just a chance, that they went somewhere, they met somebody, and just, oh, would you like to work on this arbitration case? And just, yeah, let's try. And for you, do you remember how you were appointed as arbitrator for the first time, whether it was a coincidence or just a chance?
I guess you are asking this question to me, Anna, but I'm happy
Yes,
to answer.
yes.
Thank you. I did my PhD on arbitration, and then I was so eager to be a secretary of an arbitration tribunal, and I made an application to so many arbitrators and to so many professors of mine. But as you said, it is a question of chance. Unfortunately, I couldn't get the opportunity to be a secretary of a tribunal. But then suddenly, I was appointed as an arbitrator in a reasonably small case, and then another one, and then another one, and then it continues. So I fully agree. It depends on chance. You know, sometimes you try very hard, but it is very difficult to get the first appointment. But the only thing is, the more you involve in arbitration environment, the more you involve in arbitration cases, whatever your capacity is, as a counsel, even as a secretary, it is very important to be in the club. And then sooner or later, when you get your appointment, you would feel comfortable. And if you have luck, then you may continue.
Thank you, Zia. So the conclusion is just to be patient also, that just to wait for a chance, work hard and be patient. Now let's look at the question from the audience. We have a couple of questions. Okay, one question from Evgeny Vasilchenko. Greetings from Paris. Many thanks to the distinguished speakers for the insightful discussions. My question is to Svetlana Iritis. From the perspective of business, would you endorse the trend to publish arbitral awards by the institutions, and would you be willing to have your awards published? If so, on what terms?
I can go first. My answer would be short, no, because that would violate one of the principal reasons why I want to go to arbitration. Yeah, it's a confidentiality of proceedings. It's a confidentiality of certain facts, certain issues, certain moments. And obviously the arbitration award is normally a quite detailed document which enlists a number of things which I don't want to be publicized, and my initial thought would be to keep them private, out of the national courts, and to keep them confidential. So no, absolutely not. I'm a strong opponent of the arbitral awards being published and publicized, because that would actually defeat one of the main privileges of having an arbitration in a particular case.
Thank you, Svetlana. Ritis?
My answer would be, it depends, and it doesn't say a lot. So maybe I just want to add a couple of practical nuances that I've had at my work in this company, and being the fact that my company is listed on an exchange. And if you are listed, you have quite an extensive list what to announce on the exchange to the investors, because any dispute may be treated as a material event for the investors. So there is an obligation to announce and to reveal, and it's kind of a struggle. So this is first point where you have to reveal the fact. You go into arbitration, then whether you should reveal the claimant, the parties, and so on. And this is first, let's say, burden, difficulty that you have to solve, and it's you can't avoid basically announcing and revealing. And in the past, I found it quite challenging because you have this burden, you have this the confidentiality, the secrecy in a good way, but you have to announce. And this was a sensitive issue. We had a couple of cases. So even in those instances, even the mere fact is a pain. So that's one thing. And then another case and example is that when you have the award rendered and you have your lawyers who represented you willing to go into the world and basically scream out and declare that they did assist you, represent you, and here is the victory, that and that, and with the details that and that. So then again, in a couple of instances, I had to say no, or at least wait and be really careful with what is being actually announced. So I would say, for the sake of I don't know, public good, we might consider publishing maybe summarized awards with no confidential and commercial information. That would be the possibility. But then again, every case is a headache for lawyers because you really have to go through and see what's permissible and what's confidential and what is not appropriate to be announced from business perspective. And there is no criteria list. So it's a difficult question, but if that helps to develop and promote arbitration, and if that helps to improve the access to arbitration, I would be friendly and supportive of some sort of summary publication mechanism.
Anna, although the question of Evgeny's question was not to me, can I jump in?
But just very quickly, because we have other questions.
To say that publication, of course, unless the parties object, increases predictability that Svetlana mentioned. So unless the party objects, I think publication will increase access to arbitration, meaning that the parties will be able to predict a little bit more the success.
Thank you, Maria.
Indeed.
Okay. The next question, I have a question concerning mediation, especially in terms of cost efficiency and time efficiency. What do the panelists think? Also in line with Singapore rules and new ICC and ICD MEDAR rules. Also, would mediation be perceived differently in terms of culture? For example, US parties are generally more familiar, while, for example, mediation as ADR is relatively new in society. Who would like to take this question?
I can answer, Anna, if you don't mind. Because in Turkey, mediation is very widely used. We compulsory mediation before any commercial cases. So therefore, in our domestic practice, we use mediation very often. And in international practice, because I involve in construction cases very often, as counsel, I quite frequently involve mediation. Especially in construction contract, it may be a good solution before arbitration, at least to settle some of the cases. And there are really very good expert mediators who can facilitate the settlement between the parties. But one problem with this is the counsels should prepare the clients very well before the mediation. So mediation is not to argue against each other, but just to cooperate to find a settlement. Sometimes you don't see this approach and it is impossible to have the settlement. But if both parties are constructive, indeed it is a very efficient way to resolve. But having said this, I have to confess that in my experience, I mean, it is not very realistic to expect all the disputes, most of the dispute can be resolved through mediation.
Thank you, Zia. Does somebody want to add?
If I can just add that you see that mediation in Central and Eastern Europe is not as successful as in some countries. But there have been mediations, and at the ICC, for instance, level, you see that mediation has more and more success. And I think last year during the pandemic, parties were trying to mediate a little bit more, and many have been successful in that. So I think that it's also there's a future for mediation as well.
Thank you, Maria. Rita, Svetlana?
I can
Any
only add
source of
that.
mediation?
Okay, I can only add that only from Lithuania's perspective, that mediation is the trend and popularity is growing up, and it's quite substantially, and it's now growing up between businesses as a mean of this dispute settlement. So again, I would say that maybe for small claims, I would be more favorable of mediation. And then again, if you have complex questions, you need an expertise. As a professor just said, you need an expertise, the knowledge of substantive law, this preferably. So I think that's the difference for choice.
Thank you, Rita.
Well, I'm more skeptical out of all of you. My position is there is nothing in between. It's either, you know, we are able to communicate with the counterparty and agree on something, or we cannot. And I'm very skeptical in believing that a third party, outside third party, can bring, can bring the situation to a solution, especially when it's, big company, with lots of people involved, lots of commercial interests involved, and so on and so forth. So normally, at the same time, I agree that it's always best to agree and not to litigate or arbitrate. That's obviously my first advice and my first question, which I ask my client, my internal client, saying, can we settle? Can we agree? Is there room for negotiations? Is it that bad? Do we really need to go and start the process? And in many cases, and this is also true, they do settle. They agree because they want to keep the business relationship going. And we are in the sphere of steel production, and our customers, obviously it's a very tight market, and we're fighting for the customer base, we're fighting for the markets, and we are very much client oriented in this respect. So we will lose money, I would say, faster than we will lose a good client. So
thank you, Svetlana.
But I don't think we will turn to mediation to do it. The commercial talks rule in this particular case.
The time flies, and unfortunately we have to finish our discussion. Thank you very much for your honesty, for your time, and I really hope that we will be able to meet next year, or maybe even this year in Kyiv.
Thank you very much, Anna, and thank you, everybody.
It's been a pleasure.
Well, I would be very, very happy to greet you in my home city. So even if you are traveling not for the arbitration conference but on some other matters, please give me a call. And thank you for the audience bearing with us and our not so fancy comments. I'm sure you knew more or most of what we said. And thank you, Anna. It was a pleasure seeing you again.
Thank you
very much.
Bye.
Dear participants, and now we will have a special presentation of the report of the Ukrainian Arbitration Association about recognition and enforcement of arbitral awards in Ukraine for the period of the last 15 years. The report would be presented by co-chairs of the working group of the Ukrainian Arbitration Association, Alexei Maslov, Senior Associate at Avellum, and Sergei Uvarov, Secretary General of the Ukrainian Arbitration Association and partner at Integrities. Sergei, Alexei, the screen is yours.
Yep. Hi, everyone. So it's a pleasure to be presenting today, and it's a pleasure for us to present the results of this study. I probably should say, as an introductory remark, a couple of words about this study and about the working group. The idea to conduct the comprehensive study of the court practice relating to recognition and enforcement of international arbitral awards appeared probably several years ago, and a working group within the association was established approximately 18 months ago. So a lot of law firms and a lot of lawyers participated in the work of this group, and we'll very briefly mention them in the end of our presentation. But although the mention will be brief, our gratitude to them is huge, because they had to. Thanks to them, we were able to review dozens of thousands of various cases. Their procedure for research was very, very difficult, I would say, and we'll talk about the methodology in a couple of minutes. I should say that but the task of this research was to be as comprehensive as possible. So that's quite simple, because we know that there had been previously the attempts to conduct the research of the court practice focusing on the particular periods of time, but it has never been done comprehensively to cover basically all available information starting from 2006 until 2020, so basically covering 15 years. Again, can you please switch to next slide, please? Yes, so that's the couple of words about the methodology. Well, we sought to collect basically as much information as possible. Obviously, we will not present all information that we collected today. So you will see the key findings of the research, and hopefully we will be able to produce some further analysis in future. Although we reviewed really dozens of thousands of cases, dozens of thousands of various court decisions, we distilled that research into 600 of cases from 2006 to 2020. These are basically only the cases related to recognition enforcement proceedings, so they do not include the cases relating to setting aside. They do not include interim measures in support of arbitration, and so on. And secondly, these 600 cases do not include the applications that were not considered and decided on the merits. This means that where the applications were returned to some procedural deficiencies, they are not counted in these particular statistics. So although we did gather information on them, this will be subject to a separate analysis, which again we will present later. And a final comment from my side on the methodology is that these cases, for each case, we analyzed and we basically noted the last available and final decision. So when we say 600 cases, this means the 600 proceedings from the very start to the very end, and not just 600 of court orders that could have been appealed, reversed, and so on and so forth. So I now pass the floor to Alexei to continue with the methodology and with the first findings of our study.
Yeah, thank you very much, Sergey. Could you please have the next slide on the screen? Yeah, so to wrap up and to add some details regarding our methodology, how we basically conducted this study. So the information we took from the public register, as many of you know, in Ukraine, most of court decisions are available through a public court register. So what we basically did was searching the register for all cases on recognition and enforcement of arbitral awards. To ensure the quality of our research, we developed at the very beginning some standard search terms to make sure that we have the widest variety of cases got into our data set. And then we divided the search by periods, which were conducted by separate law firms. After the initial search, we made a cross-check of quality of research, where the other firm, not the firm which was making the first search, made an additional search to make sure that most of the cases, or ideally all of the cases, are in our data set. And after, we reviewed all the cases from all the periods and combined them into the one table, Excel file, which contained all the cases. So we did our best to make this research as good as possible, but of course there could be some mistakes because it was information from public registers collected by humans, and humans make mistakes. But we believe that still we get quite representative picture of Ukrainian court cases, because indeed 600 cases is quite a lot, even for such a long period. Another caveat which we would like you to keep in mind is that Ukrainian courts may be quite economical when writing their judgments. And in our data set, we tried to collect quite a lot of data. So if possible, we try to collect data about applicable arbitration rules, the seat of arbitration, law of the contracts, law of the arbitration agreement, if possible, the types of claims made, the arbitrators and the number of arbitrators, dates when the arbitral proceedings were commenced, and so on and so forth. However, not in every case does the court mention all these details in its judgment. So this is something that also must be kept in mind. And the final point is that another issue of interest for us was to consider to refuse recognition and enforcement were most often invoked by parties and taken into account by Ukrainian courts. And once again, it's not always very easy to articulate which particular grounds were invoked from the descriptions in the court judgments. And the reasoning of the courts may at times be not clearly articulated between different grounds. But once again, in most of the cases, we found we were able to make this and to get this additional data. So with these few words about the methodology of our research, let's go to the statistics, the data we have found from our... Could you please go to the next slide? Thank you. So the first thing we would like to share with you is the number of cases that were decided in each year from 2006 to 2020. You will mention that in this and in further slides, we take together years 2006 to 2009, because in that period, the court register didn't work quite well, and the courts were quite inaccurate and did not enter their decisions into the register as regularly as they do it now. So we combine these years. But in any event, this graph shows a steady dynamic of growth of the number of cases which were decided each year. As you'll see, in 2020, more than 80 cases were decided, which were approximately 30% more than in 2019. So we believe that this is a good trend. The only thing we would also need to consider when looking at this graph is that in 2020 we took decisions that were final as of 2020. So, for instance, if we had a decision by the court of first instance, which was not yet appealed, we entered it into our table. However, it is possible that this decision would be appealed in 2021, and then the final decision, the decision of the Court of Appeal, would be in the statistics for 2021. So this may explain the steep difference between 2019 and 2012, but we believe it still doesn't negate the fact that there is a trend for more cases being decided each year. Could we please now go to the next slide? Thank you. Yeah, it's this is basically was one of our main ideas and main goal behind this research. We wanted to see how often Ukrainian courts do recognize and enforce arbitral awards fully or partially, and how often the recognition and enforcement was refused by Ukrainian courts. So the statistics was quite good, and we believe that this is an evidence of pro-arbitration bias of Ukrainian courts, because in each year from 2006, more than 80% of cases were in more than 80% of cases, the arbitral awards were recognized and enforced, partially or in full. And for instance, in 2019, more than 93% of cases got the recognition and enforcement of arbitral awards. One word about the statistics for 2020. Because it may seem surprising that more cases were recognized. In more cases, awards were recognized and enforced in 2019 than in 2020. But we do not believe that this is a trend of Ukrainian courts getting less pro-arbitration. It is sooner the fact that in 2020 there were quite a lot of cases which dealt with decisions in which sanctions adopted by Ukraine against the Russian Federation went into play. And these cases, there were quite a lot of them. In them, the recognition and enforcement was refused based on public policy reasons and sanctions. So this may make a difference in this particular statistics. And another thing is that, as I have previously told, some of the cases that are in our data set for 2020 may yet be appealed, and the Court of Appeal may overrule the decision dismissing recognition and enforcement and actually recognize and enforce those awards. So the statistics for 2020 are not as bad as they may seem. Serhiy, now pass the floor to you.
Next slide, please. Next slide, please. Yes. So basically, the second most important aspect that we wanted to study in this research, together with the rate of recognition, was the duration of cases. Because to say frankly, I was quite sure that in all years within our research window, we had more or less good statistics as to the recognition rate, and this proved true. But I really did not have any understanding as to the average duration of the proceedings. And this is basically one of the most frequent questions that we as practitioners get. So how long it's going to take if we are going to enforce the arbitration award in Ukraine? And basically here is the answer. So here we have the annual statistics in days, how long the average recognition proceeding would last. So, for example, the cases decided in 2011, where the final decision was rendered in 2011, the average duration of proceeding was just 187 days, so approximately half a year. And you also see that from 2011 to 2019, the duration was growing gradually but steadily. And in 2019, it was already 395 days, which is approximately 1 year and 3 months. And again, I should remind you that this is the average, which combines in itself basically both extremes, both the cases that were not contested and opposed at all and could be decided very quickly by the local court within a month or two, and cases that were heavily contested and basically that ran through several rounds of review, and those proceedings took much longer. However, again, as an average indicator, based on quite significant amount of data, we believe that this graph does provide a general understanding of how long the proceeding, the recognition proceeding could take in Ukraine. And taking into account that this is an average, we also wanted to show you some extremes, and they are on the next slide, please. So here we have the record-breaking cases, and as you may see, we had 30 cases that lasted more than 3 years, 12 cases that lasted more than 4 years, and the most record-breaking are the cases that lasted more than 6 years. We have 3 of them, and just 1 case that was absolutely crazy and lasted more than 9 years. Again, you will appreciate that we are talking here about small portion of cases as compared to the overall amount, approximately 600 cases. So this is rather an exception, but we wanted to show you how bad such exception could be. Importantly, all these cases, all these record-breaking cases, they were commenced prior to the arbitration reform of 2017. And this is another aspect which we really wanted to research. What was the impact of the arbitration reform of 2017? And from the previous slide, you could have who could get an impression that the arbitration reform did not significantly impact on the duration of the proceedings, because in 2018, 19, and 20, the duration was still very high, basically the highest in our research window. However, this statistics does not reflect correctly the impact of the reform, and to reflect it correctly, can we move to the next slide, please? Yeah, so here, why the average statistics does not correctly show the impact of the reform? Because in cases decided since 2018, those cases include both proceedings that were commenced under the old rules and commenced after the reform. So if we took them, if we separate these two categories, we have a very different statistics. So this is the first graph on this slide. So if we take into account all applications decided since 2018, the average duration will be over a year. And if we take only the applications that were filed since 2018, that is under the new procedure, the duration will be almost twice less, which is very significant. And another interesting statistics is on the second graph of this slide. Here we took the contested cases, which means that we took the cases that were appealed and thus excluded the most simple case, if we can say so, where basically no one opposed recognition and enforcement. So this graph basically answers the question: if I want to have my award enforced in Ukraine, and I know that the respondent will contest such recognition and enforcement, how long will it take? And again, the statistics is quite telling here, because the applications that were filed before 2000 568 days, and for the applications filed since 2018, the average duration is almost twice less. So the impact of the reform is quite significant, I would say, on the duration. And next slide, please. I can't say that the impact is significant in terms of recognition rate, and this was also, I think, clear from Alexei's graph, because as you see on this slide, the rate of recognition before 2018 and after 2018, the average rate, I mean, remains virtually identical. So it's around 90% of cases are recognized, both before 2018 and after 2018. Alexei, the floor is yours now.
Yeah. Next slide, please. Yeah, so another thing which was very interesting for us, naturally, was to understand which arbitration rules are most popular among businessmen who come to for their awards in Ukraine. So would go to the combined second place, would go to International Arbitration Court and International Commercial Arbitration Court from Belarus and Russia, respectively, which together had around 15%. When viewed combined, ICC, SCC, LCA, Vienna International Arbitration Court, GAFTA, and FOSFA, so to say Western arbitration centers, together account for around 10% of all awards, and the other arbitration institutions, which included a wide range of centers from Middle East, China, Eastern Europe, and so on and so forth, accounted for around 20%. So this was not something unexpected, but it is interesting to see which arbitration centers are most popular among Ukrainian users. Next slide, please. Yeah, and we also were interested to see, out of all cases in which recognition and enforcement of an arbitral award is refused, what is the distribution among different arbitration rules. So here we see that once again, for Ukrainian International Commercial Arbitration Court, the rate is 23%, which is in fact quite good, because for an institution which amounts for 56% of all cases, the negative rate of 23% is quite good, I believe. But the leadership is perhaps with, once again, combined Russian International Commercial Arbitration Court and Belarus International Arbitration Court. Unfortunately, there is a typo here on the slide. It's actually International Arbitration Court, which together amount for 35%. And with Russian International Commercial Arbitration Court, this might be a trend which would only rise in future, because as I have previously told, the public policy exception applying to sanctions, Ukrainian sanctions against Russian Federation, make a good argument for award debtors to refuse recognition and enforcement. Then we have Stockholm Chamber of Commerce, which amounts for 10% of unrecognized cases. Perhaps there were quite a lot of emergency arbitrator awards which contributed to this particular trend. and Gafta Phosphor and amounted for another 5%. For all other institutions, the rate was less than 5%. Please, next slide. Yeah, and the final data set, the final statistics we would like to share today is also very interesting. We wanted to understand which grounds for refusing recognition and enforcement under Article 5 of the New York Convention were most oftenly invoked by debtors under arbitral awards, and which of them were eventually upheld by Ukrainian courts. And perhaps it was not, once again, surprising for us. It was something we understood from our practical experience, that the grounds under Article 5.1b and 5.2b, namely failure to notify about the dispute and public policy exceptions, were most common and were invoked most often. And the least popular was Article 5.2a, the concept of arbitrability. Perhaps for many award debtors and for Ukrainian courts, the concept of arbitrability is still too complicated to crunch. Perhaps that's why it was not used so often. But what is interesting on this slide is that all of these grounds, even those which were invoked most often, actually play out in favor of award debtors. Quite rare enforcement, which is quite low rate of below 15%. The same goes for the public policy exception. And if we account for the situation with Russian sanctions I have described earlier, the success rate is even lower. And generally, if we compare all the figures, we see that for each ground for recognition and enforcement, the success rate, the probability of court actually upholding this ground is less than 15%. So it's quite encouraging, and you can actually tell your client that even if the debtor raises any of the grounds under the New York Convention, the chances that this ground would be upheld by Ukrainian courts are below 15%, which is an encouraging thing to say. Sergey, please.
Yeah, next slide, please. Just a couple of words. So that basically concludes our presentation of the findings. And in future, we plan to prepare and publish a more detailed report based on the information we collected. And also, quite importantly, we plan to continue research in further years, and I trust with a particular emphasis on the practice of the Kiev Appellate Court and separately of the Supreme Court. So now it is possible to monitor them very precisely and very specifically. And finally, the concluding several concluding remarks is, as I promised in the beginning, words of gratitude to the firms and people who participated in the research. And next slide, please. Here we have the firms, Ukrainian firms, who were kind enough to participate in the research and provided enormous support to us, and to whom we are very much grateful. And on the next slide, please, we have the participants, basically, who conducted the research, prepared, reviewed the court register, prepared the data sets, analyzed them, and so on and so forth. And again, we are very much grateful to them for this. That's it. I think this concludes our special presentation. Thanks, everyone. Hope you enjoyed this.
Yeah, I see that there are no questions in the chat. just some work to do from us too. Thank you very much. Yeah, another thank you. So yeah, I think this, if there are no further questions, this concludes our presentation. Thank you very much. Thank you, Sergey, for co-presenting, and see you further during this conference.
Dear participants, now we have a technical break for 5 minutes and we'll resume in our conference in 5 minutes with the second session of the conference. Good afternoon again. Dear participants, we continue our program and invite you to join the second session of the conference, which is going to discuss the topic of decision-making in arbitration. For those who joined later, my name is Elena Priplitska, Pilinska. I'm president of the Ukrainian Arbitration Association and head of arbitration at Integritas. I'm very glad to introduce our panel. Teresa Giovannini is a founding partner of LALIV. She has acted as counsel and arbitrator in more than 200 international arbitrations under various arbitration rules. Teresa is a Swiss member of the ICC Court of International Arbitration and performed various functions in other arbitration institutions and associations, and she is frequent speaker and lecturer on international arbitration. She has been also as in our period and most responsive arbitrators by Global Arbitration Review. Our next speaker is Professor Catherine Rogers. She's professor of law at Bocconi University and has dual appointment at Queen Mary University of London, where she also co-directs the Institute of Ethics, Regulation and Commercial Law. Professor Rogers is a reporter for the American Law Institute's restatement of the U.S. law of international commercial and investor-state arbitration. And among her research projects, Professor Rogers co-chaired the ICA Queen Mary Task Force on Third-Party Funding in International Arbitration, and she is founder of Arbitrator Intelligence, a global information aggregator and legal tech startup. Our next speaker is Marc Henry, partner at FTMS Avocat, Paris, and president of the French Arbitration Association. Marc has been a lawyer in Paris for more than 30 years. He specializes in business litigation and arbitration and sits as arbitrator. His doctoral in law and his PhD work was about the duty of independence of the arbitrator. And he has strong doctrinal involvement and is lecturing in several master courses in arbitration law and the art of advocacy. We also have the fourth speaker, the Justice of Ukraine's Supreme Court, Constantin Pilkov. Unfortunately, he has been called to join an urgent a hearing of the Grand Chamber of the Supreme Court today, but I hope he would be able to join us a bit later and participate in our discussion, but I nevertheless will introduce him now. So Constantin is not only Justice of the Supreme Court, he is also Associate Professor at Kyiv National University for Trade and Economics, and Senior Research Fellow of the Scientific Research Institute of Private Law and Entrepreneurship, named after academician Burchak of the National Academy of Legal Sciences of Ukraine. He has PhD in law and master degrees in law and psychology. And before his appointment as a member of the judiciary, Constantin was arbitration practitioner. He was also counsel and arbitrator and was listed by several arbitral institutions. He has PhD focused on matters of evidence of proof in international commercial arbitration, and as a justice he also authored several opinions that promoted arbitration. So with that, I suggest to go to our discussion. And we have a fascinating topic. So arbitral award is an end product of arbitration. And actually, this is the main reason, or one of the main reasons, why we refer the disputes to arbitration. However, how exactly the decision-making process works? This is a very complex topic, including both psychological and legal issues, and that could be addressed from different perspectives. So let's start from the arbitrator's perspective and with the topic of efficiency and integrity in the decision-making process, hurdles and suggested solutions. So Teresa, you are a very experienced arbitrator and have had hundreds of deliberations with co-arbitrators. Could you please share with us your observation regarding the decision-making process and related issues?
Thank you very much, Olena, and hello everyone, the one I see in the panel and the others I don't see, much to my regret. I would like to be in Kiev, but unfortunately it is for later. I would like to, in the little time allocated to me, I will try to show that efficiency and integrity in the decision-making process is something which meets some hurdles, and would like to suggest some solution in that respect. Users expect the arbitration process to be both fair and efficient in terms of time and cost, which is absolutely normal and legitimate. And in that regard, as put by one of my current colleagues, Swiss colleague, Dr. Berger, I quote, "From the party's perspective, you know the arguments and motions put forward in the proceedings, that is the input. You can see the result in the form of the dispositive section of the award, that is the output. And then you can try to understand the reasons given for decision in the award, that will be the transfer element. All the rest that may have happened in the deliberations remain undisclosed and undiscovered, what many call the black box." So let me turn to the unclosed element, the deliberations. Mr. Mosk, a very remarkable author, and I am sure Catherine is aware of, has written about deliberations of arbitrators and has written what follows. "An important component of any dispute resolution mechanism involving more than one decision makes the deliberation, being recalled here that statistically a vast majority of international arbitration tribunals is composed of 3 members, a setting that constitutes the fallback rule in the Untitled model law that has been adopted by many arbitration countries. Deliberations are held as mandatory in most national laws, as held by the French Court of Appeal. The requirement of deliberation is a fundamental principle of the procedure, which guarantees the judicial character of the decision reached by the tribunal, arbitral tribunal in that instance. The principle of collegiality assumes that each arbitrator will have the possibility of discussing each decision with his colleagues or her colleagues. So what is the problem? The problem is that this setting, which is very known and common in ordinary courts, it doesn't pose any problem within this kind of background, because all the judges belong to the same cultural and legal background. Conversely, deliberations in international arbitration tribunal have nurtured important debates connected to both the integrity of the process and time and cost involved. Why is that so? The answer lies essentially with the parties' right to agree upon any procedure for appointing arbitrators. And I think Mrs. Rogers, Professor Rogers, will tackle this issue, and more specifically to choose their arbitrator, a fundamental feature in arbitration that is embedded in Article 11, for example, of the Untitled model law, and in almost all modern arbitration laws and arbitration rules. And the result well arbitration of an additional advocate of the views of the his or her appointing party. Bias has been said to be conscious or unconscious, tantamount to self-serving or egocentric interest, equivalent to misconduct. But little has been said to the most serious and most commonly common bias, which is the cultural bias that stems from the differences in legal and or regulatory systems, nationalities, cultures, education, and backgrounds. Conversely, as I mentioned, the judges share legal background. And thus, for example, in the States, practice of partisan party nominated co-arbitrator was historically common until 2013, for instance, where the AAA, the American Arbitration Association commercial rules, provided for presumptively different standards of independence and impartiality for co-arbitrators and presiding arbitrators, called tellingly neutrals. In certain European countries, I would not give any and not identify any countries, because it's not something to be ashamed of, but it's something belonging to a given culture. It's the party's appointed arbitrator role is understood in the advocating the party that appointed him or her. Different, if not opposite, legal approaches to procedure, adversarial versus inquisitorial, for instance, can also create this kind of cultural bias. What are the practical consequences of this cultural bias? bias is that arbitrator seeking to persuade a passive presiding arbitrator. Such negotiation, as put by my learned colleague Mr. Patoki, often leading to situations, I quote, in which one arbitrator is amenable to concur with another, provided that the point is conceded. I give you an example, which is very frequent. It's a mild decision on the quantum as a result of a clear and unanimous affirmation of liability, a situation that everybody is aware of. This bargaining process also triggers important consequences in terms of effort, time, and cost in the so-called discovery phase, but I will not tackle this at the time is too short. So where are there some solutions? This problem has been the subject matter of various debates and conferences. But as put by Professor Pierre Meyer, a learned authority in the field, I quote, the best way to arrive at a unanimous award, or at least to diminish the inconvenience of bias, is to start discussing the various aspects of the case rather early on, unquote. Along the same concern of avoiding bias, it has been suggested as early as possible in the proceedings, some suggest at the outset, that the arbitral tribunal plans and paves the way for how to approach the issues that will have to be resolved and the methodology by which the decisions may be accomplished. Others go further in advising that the points to be proven be discussed and identified at the first procedural meeting. Others still recommend that the issues, the real questions to be decided upon, be identified by the tribunal as early as possible in the proceedings. So how to identify the issues to be decided upon as early as possible, which is one of the solutions that has been argued and proposed. Identify, we have all of us gone through this situation where during the deliberations one of the arbitrator put forward a solution or an argument that none of the parties has thought about or even argued. And the second solution is that when this decision tree is set up amongst the arbitrator, is sharing the list of issues with the parties. This route requires that a very detailed decision tree be made, be elaborated at a time, where, as I said, where the dispute is in all its aspects put on the table. I would put that moment at a time where the written phase before the hearing is completed, and then that this decision tree be put to the parties for determination. The sharing of the decision tree with the party has proven to be very efficient. For instance, in a particular difficult situation of bias that has been reported by someone many of you know, Dr. Mark Blessing. Now he is occupied with music and arbitration for his past profession, where one arbitrator was playing in the deliberations the role of both the defaulting party's counsel and that party appointed arbitrator, where the chair decided to rescue the unbalance between the parties by totally opening up the deliberations phase based upon a detailed questionnaire that was circulated to the parties. Mark Blessing, the chair who reported the case, as I said, explains, I quote, interestingly, while the parties and arbitrator had taken the advocate's hat for the defaulting respondents, he thereafter was perfectly able to then wear an arbitrator's hat when sitting back and discussing the final decision we had to make. Professor Pierre Lalive, my mentor and the co-founder of the firm, I was rather the co-founder with him rather than the other way around, has done the same way where there was a leaking of the draft award to one of the parties. Faced with that situation, rather than cancel the whole proceedings, Pierre Lalive put the draft to both parties and put a series of questions to both of them, asking them to answer, and so that there was no bias possible anymore, because this was open to the parties, and therefore any bias could be avoided or at least eliminated. There are surely other routes to avoid this kind of problem that is very known and in the culture, but I leave it to the panel and maybe to the floor to suggest maybe other solutions based upon their experience or their expectations. Thank you very much for your kind attention.
Thank you, Teresa. Mark, Catherine, do you have any comments?
We can't hear you, Catherine. I can't hear her.
Pardon me. I think it has to happen once every conference these days. I had my mute on. So first of all, let me thank the Ukrainian Arbitration Association for hosting what's been a terrific event, and for Teresa for starting us off with such stimulating ideas and thoughts. The one kind of point I'll make to, I think, lay some groundwork going forward is that we have in many ways a linguistic problem here, the word bias. So we use it with multiple connotations, but the word itself has a lot of limitations that restrict how careful we can be in our language discussing this issue. So bias always sounds really, really bad, and I don't want to give away too much of what I might say in my own remarks. But when Teresa talks about cognitive bias, what she's talking about, even though we use the word bias and bias sounds bad, is really in part of the human condition. And it's something that no matter how hard we would like to deny it or repress it, we are all subject to certain cognitive biases. It's part of, again, just being human. On the other hand, I think there are separate questions and behaviors that Teresa identified where bias, in a sense, becomes a form of professional misconduct, where it's a sort of an abuse of power or a misuse of power to advantage one side or the other. And even though we don't have clear linguistic divisions between these, and it gets very messy to try and start talking, try and start parsing these, and sometimes we use the word neutral or partial or impartial. But the problem with all of these terms is that they're binary, or unbiased. And you cannot really parse the different types of bias. But just in this example, in her opening remarks, I think Teresa's done a nice job of setting the scene for what would be a continuing theme in the rest of the panel, which is there are at least two categories we can talk about and are talking about. One is cognitive biases, oftentimes referred to as unconscious biases. Some of those can be, in fact, very positive. Some of those can be ones we don't know, but in fact are negative. A lot of discrimination is considered a product of unconscious bias. And that's different from or distinct from some of the kinds of bias that are considered unacceptable in adjudicators and that might be disruptive in the proceedings. I thought Teresa's examples were very interesting, including the procedures for trying to cure them. And when those examples of bias become too prominent and affect the procedures too much, they may even become a basis for challenging the award. Or for challenging the procedures during the procedures, disrupting the procedures, and later for challenging the award. I think with that, those are my comments on Teresa's nice opening, but Mark may have something else to add as well.
And thank you. Yes, I think it's important to keep in mind that you have different words which have different meanings. Bias is a very large one. We don't have this word in French, really. In French, we have partiality, which is something which is more restrictive than bias. So, of course, when you were taking, Teresa, when you were talking about having an unanimous award in order to prevent from bias, you can have an unanimous award without having an arbitrator being biased. I mean, you have a dissenting opinion is not a traduction of the bias behavior. So bias is something which is very large. It is not partiality. And as you said, Catherine, it is something very interesting. It is all what we call unconscious bias, which are not partiality. Well, it can be partiality, but it is much larger. And it brings to the question of neutrality. And neutrality is a real issue which has not been very much explored in arbitration. In fact, I was asked to give an opinion on the question of neutrality and whether it could base the challenge of an award. And it's quite interesting because you don't have much things about neutrality. And so neutrality poses the question of the absence of any bias of any kind. And that's interesting. Something to explore.
Thank you all. Before we move to the next topic, I have a question to all of you, probably to spark again our discussion. How do you think whether the current trend to discuss diversity in arbitration would have an impact on decision making? Because so it's quite clear that when the tribunal is composed of quite similar person, it's easier to agree rather than once it's composed of diverse person with diverse background, geographical and all other aspects. So what do you think? Is it good or bad?
Just to understand your questions, what do you, I am not very familiar with, because we hear this word 10 times a day, but we are not sure it covers always the same concept. I would like to know what you imply, because when we speak about international arbitration, for sure you will have 3 arbitrators coming from different legal background and nationalities, culture, and more often than not language. So is that a concept of diversity that you are referring to?
It is.
Now,
yeah, also
including,
so to say, yeah. So
I would personally
I would
say that, if I may, I would personally say that it is in the context of deliberations and international arbitration tribunals. I have gone through a diverse form of diversity in the sense that we hear every day. Men towards women, people of color towards people, etc. I must confess it's difficult for me to tackle this issue. I think it's a very difficult issue. But be that as it may, I think the main, in the deliberations process, the main issue is the differences in the culture, in the cultural background, in the legal background, and much more than other form of diversity that we might refer. I just wanted to clarify, to clear the ground, as far as I am concerned, in my experience.
Mark, Catherine, anything to it?
Teresa said, in that I think really international arbitration was sort of founded on the notion that once you get into decision making at the international level, you're necessarily dealing with people from different legal cultures. And we need to have a system that can responsibly handle those differences and find justice despite these differences and taking account of these differences. And I think today we are facing what is, I think, rightly has been considered a bit of a crisis, in that the other reason why diversity is important is one of the ways that we take account of different legal cultures is by having representativeness. Not to say that arbitrators are representatives of the parties, but they provide representativeness on the tribunal. And I think as part of the decision making, and as we talk about cognitive biases or unconscious biases, that representativeness, making sure that people who are part of the dispute resolution community and who are part of individual disputes can see that their viewpoints, that their concerns are fully addressed and addressable by the tribunal, I think really is how we link the larger questions of diversity, which go to, I think, questions of fair access for people and the sort of legitimacy of the pool of arbitrators as a whole to the individual disputes? And do we see the justice that is described as transnational as being truly something that everyone can see themselves in and see their own the representativeness of their legal cultures and interests in the decision-making process? So I think that's part of what the hard work that international arbitration has done, is working to harmonize these different legal cultures. Today we have just, I think, a much broader range of inputs than we used to. And so a broader range, you might say, of cognitive biases that everyone wants to see being identifiable within both the community and individual tribunals.
Thank you. Mark, any comments?
No, I will simply say that I don't think that diversity makes the deliberation more difficult. In fact, I have had deliberation within a Franco-French arbitral tribunal, which were very difficult. So it does not make the deliberation more difficult, but it makes the deliberation much more interesting in my sense. So that's one thing, because you have, I mean, this diversity of culture, and that's very interesting to confront these. But and of course, if you were talking and if you were meaning the gender diversity, I would say it's absolutely essential, and of course much better to be and to deliberate with women, not only with men, if possible, at least.
Thank you. So let's move to the counsel perspective of our topic. Mark, so you are an experienced advocate and you teach the art of advocacy. Could you tell us how advocacy can influence decision-making process in arbitration?
Yeah, thank you. First of all, Olena, I want to thank, of course, the UAA for its invitation to speak, and especially Olena, of course. Again, thank you. It is an honor to represent the French Arbitration Association at your first annual conference. But let's come to my topic. So, how advocacy can influence decision-making process in arbitration? Well, to live is to choose, and to choose is to decide. In our life, every day, at every moment, we make choices, and therefore we decide constantly, even if we are not aware of it. For a long time, psychologists, I'm not talking about philosophers, were not interested in the process of making a decision. In the last 20 years, the situation has changed. Studies have multiplied, mainly in the US. You may ask, well, how can the studies on the decision-making process of mainly American juries be of interest to arbitration? Well, the reason is that in arbitration, justice is not the work of an institution, as it is in civil law countries. Arbitration is the work of individuals, as it is in Anglo-Saxon justice. Arbitrators are not attached to a specific legal order. They are the actors of an embodied justice. Therefore, they are not only cognitive thinkers, they are also affective thinkers. Advocacy in arbitration shall aim to act on both cognitive and affective levels in order to win the case. Benjamin Franklin stated that if you would persuade, you must appeal to interest rather than to intellect. It is why the psychological studies conducted on decision-making in the US were very quickly of interest to the actors of arbitration. The aim is to understand in order to better anticipate the decision-making of arbitrators. Once the drivers of arbitrators' decision-making are better known, it becomes possible for counsel to adapt their argumentation to the psychology of arbitrators, to maximize the efficiency of advocacy. So I will address three questions rapidly in my speech. What is the objective of advocacy? What are these psychological drivers? And how shall advocacy interact with these drivers? First, well, the objective of advocacy in arbitration is to facilitate the role of arbitrators, of course, in their mission to judge. But what does the mission of judging entail? According to a former president of our Supreme Court, to judge means to enjoy listening, to try to understand, and to want to decide. Thus, in order to serve its purpose, advocacy must be part of the process that leads. Therefore, advocacy must serve in mirror what the judge said, I quoted, so it must serve the listening, the understanding, and the decision. That leads to one question. To serve such ends, shall advocacy aim at informing, educating, attracting, creating empathy? In fact, all of these at the same time. But one additional question then, for what ultimate purpose? To convince, to persuade, or to complete the process of convincing or persuading? Response, again, the three of these. Advocacy must successively aim at convincing and persuading. But now one needs to identify the drivers of the conviction and persuasion processes in order to influence decision-making. What are these drivers? The decision-making process is the result of both intuition and deduction, i.e. a process that combines subconscious intuition and conscious deduction. Any judge, and therefore any arbitrator, can be influenced in his decision by psychological drivers. What we call cognitive biases is what Catherine mentioned. Since the objective of advocacy is to influence decision-making, it must act on these different subconscious biases in order to predispose the arbitrators in a direction favorable to the defendant's thesis. So, what are the drivers of the art of persuasion? In French, we say decision. Je prends une décision. In English, we say to make a decision. This difference is where in wording it. In my sense, the English formulation better reflects the decision-making process. A decision is something that the individual shapes rather than something pre-existing that one simply slaps and takes. Because the decision is something that is shaped, advocacy shall aim at incorporating this creative process by inserting into the psyche of the arbitrators and accompanying the arbitrators in their decision-making. Latin rhetoricians already identified the three drivers of persuasion: docere, to teach; movere, to move; delectare, to please. The vision is still relevant. It is by playing on these three drivers that advocacy will be able to act on the arbitrator's subconscious biases in order to persuade them to agree. But what are the techniques to play on these different biases? There are four. First, know your audience. Knowing your audience in arbitration is an interest in the psychology of the arbitrators. And how can advocacy force the attention of the arbitrators? By playing with the two types of information that can be transmitted to an audience: cognitive information and affective information. This leads to the question of how the information delivered by the litigant is likely to circulate in the minds of the arbitrators. Well, there are two levels of information. The surface structure, this is the interaction of the brain with the information received and transmitted by the five senses. And the deep structure, it is the interaction of the brain with the information carried by experience, values, opinions, etc. The so-called ocean test illustrates the way in which the surface structure works as opposed to the deep structure. It is easy to imagine what the surface of the water is as opposed to the depth. But how shall we dive from the surface structure to the deep structure in order to be able to interact with the deep structure, i.e. the belief level, and maximize the chances of success in not only convincing, but also persuading? That means cumulative and not alternative. The storytelling and the message. The storytelling, as you may know, there are two levels of information. There is a raw information, this is the factual data. And there is a reprocessed information, this is a narrative. And the two levels of apprehension of information address the two levels of perception of the brain. The factual data feeds the surface structure, and the narrative is the deep structure. The narrative is the story of the case. By telling a story, by giving a color to the facts, we interact with the affective process by adding it to the cognitive process. Now you have the means. You have the message. In order for storytelling to serve its purpose, it is important to distinguish between two notions, the understanding and the knowing. What is the most important thing in the art of persuading? What will enable the argument to be better registered by the arbitral tribunal in making? Well, the answer is the understanding. And understanding requires knowing the meaning, which in turn requires getting clear messages, and the whole being framed so that the meaning with the messages can be printed in the brain. So, meaning, message, and frame. But is it enough to structure storytelling to increase the chances to interact with, or on the contrary, to dismiss the cognitive biases feeding the decision-making of the arbitrators? So is it enough? The answer is no. The ultimate goal shall be to go beyond the cognitive drivers of the arbitrators to target the beautiful in order to interact with the intuition. So my last mantra will be target the beautiful. But intuition is a driver that is all the more powerful because it escapes reason. There is a formula I like which says intuitive reason is a reason that ceases to reason. It resonates. In the Kantian approach, to act on intuition is to escape from rational criteria to act on aesthetic drivers of beautiful. What is there to understand in the beauty of a rose? Precisely nothing. Beauty does not require an explanation. As the German poet wrote in the 18th century, the rose is without reason. Thus, by giving a color, storytelling must tend to provoke in the mind of the arbitrator an aesthetic judgment that will convince him or her of the beauty of the decision he or she is going to make. That's called, as Hegel said, beauty of truth. Thus, by targeting the beautiful, one targets the feeling of right and truth in the arbitrator, and one completes to persuade him or her. Last word. Dear listeners, you may think that, well, these reflections were somewhat abstract and foreign to the arbitration matter. Well, on the contrary, I believe that they are essential to this matter. Indeed, it is the aesthetic criterion that will make justice escape from automatization. You will hear Catherine about it. But which justice? Arbitral justice, precisely, and less state justice. It is because in arbitral justice, the parties will still be able to give to arbitrators attentive to their feet the color to the facts that arbitration will remain the best form of justice. Let us beware of transposing to arbitration the positive models of state justice. Doing so, arbitration will certainly lose its soul, but worse, it will lose its beauty. Thank you for your attention, and sorry for having been a little bit late.
Thank you for your comments. Catherine, Teresa, do you have something to add with your perspective?
If I may, Catherine, you want to take the floor?
No, Teresa, I think it's all you.
I am delighted with what I heard because it's exactly being on the other side of the table, namely having spoken as an arbitrator. I think you, Mark, spoke about legitimacy of a decision, be it judicial or arbitral. And legitimacy goes through objective and subjective comprehension that leads to the global comprehension. A very famous philosopher in France, Morin, has published about that, and before him Kant, and before Kant Eschyle, 5th century before Christ. So I think you are, and this is so important that indeed as arbitrator we have to catch both the facts, the objective comprehension, and the subjective comprehension is core to a legitimate decision. So I cannot adhere more to what you said, and I have indeed given some some conferences on that subject that is so important, because people comes with thousands of facts, thousands of paper, of letter, of email, and forget that there is a very scope to reach, which is to make to have a legitimate decision and to lead the tribunal to understand what would be the legitimacy in that regard, having both the winning and the losing party understand, in particular the losing party, and also for the winning party, because I am sure you have crossed situations where the winning party, there is never one 100% winner and 100% loser, but be that is may, the winner wants to understand why it won. It's not sufficient that he got it. He wants to know why. And this is something very important also, obviously, for the losing party. So I cannot adhere more, and I thank you very much for having tackled something so sensitive, Mark. Thank you.
Thank you, Teresa. Catherine?
I'm not sure I have anything to add to
Okay.
Mark and Teresa's comments. I thought they were quite comprehensive,
Okay.
but I'm happy to pick up to move forward.
I suggest then to move to the next topic of our discussion. So we have discussed the arbitrator's perspective, the counsel perspective, but there is one more interesting angle of the topic, and whether the arbitrator's past decision could have any implication or impact on his or her future appointments. And Catherine, as your founder of Arbitral Intelligence, you certainly know more than we all taken together about implication of decision making for arbitrator selections and related issues. So could you tell us about this, please?
Thank you. So since we started with arbitrators and then counsel, I think you might frame my issue as parties' biases or parties' perspectives, parties' questions about cognitive bias. I really liked, I have to say, there were so many interesting things to draw from, but one that I want to pick up on was Mark's, I would say, reframing of the term cognitive bias, which is a very loaded term, again, because we use bias to describe both very harmful types of bias, like prejudice, racial prejudice, gender prejudice, but also kind of neutral biases that he says are what we might call psychological drivers. You might also refer to cognitive biases as decision-making preferences or decision-making proclivities. If you want to be even a little more provocative, you might say these are experience. They're essentially the manifestation of our cognitive processes as a result of our legal culture, our legal training, and our personal and professional experiences. I want to start with this observation that these are incredibly important. If you wanted to have a truly neutral, a truly impartial outcome to a decision, there are ways to do it. You would flip a coin, you would roll a dice. But those, while they are completely neutral, could never be determined to be in favor of one or the other. They are not the kind of reasoning that we require. And that reasoning, in recent days, we said, well, maybe this reasoning could still be neutral if it was a machine, if it was artificial intelligence. I don't think, and the research is showing, even artificial intelligence really cannot be truly impartial, because it's shaped by what it's fed in terms of its learning, but it also has no common sense. And in fact, I think one of the key features that we are looking for when we choose arbitrators is their ability to bring common sense, professional sense to the decision-making process. And this is essentially bringing their experience, bringing their decision-making proclivities and their own psychological drivers. That is why we want to choose, when I say we, I mean that's why parties want to choose their own arbitrators. Why? Because not only does each arbitrator have psychological drivers or cognitive biases, but each party does too. The parties, the opposing parties, oftentimes, I would say only in rare exceptions, do not see the dispute as something very different from their own perspectives. Sellers have different perspectives than buyers. Licensors have different perspectives than licensees. Purchasers have different perspectives than manufacturers. And so they're looking to appoint an arbitrator, someone who shares a sort of psychological driver, an experience, a decision-making preference that's similar to theirs. So that's why parties do do want to and oftentimes prioritize the ability to select, quote, their own, to select at least one member of the tribunal and have input on the third. But what does that mean in terms of the selection process? Well, historically, and I'll say something maybe a bit provocative here because it's a little counterintuitive. We don't choose anymore, I think, arbitrators based only on their resumes. That is, I would say, necessary, that they have good credentials, excellent education, and a lot of experience. But we don't choose them for that. We choose them instead, going back to what was said earlier, for their decision-making preferences and how well they are understood as aligning with parties. And so what does that mean for arbitrator selection? It means historically that we would choose by proxy. If you wanted plain meaning analysis, you might choose an American who uses the parole evidence rule. If you wanted very little document production, you might choose a civil law trained arbitrator. These proxies, I think, have really broken down as we see a lot more cross-pollination in these legal cultures, and so they're not really sufficient. So what came after the proxies? Personal references. We pick up the phone, we call around to our professional network. We say, how do you think they would approach this kind of a legal issue? How do you think they would approach this kind of procedural issue? And we're looking again for feedback to help us understand the experience and how it will inform the decision-making preferences. And that's important when Mark said, know your audience, okay? Part of what parties are trying to do is pick their audience so they can understand, so they make sure that they know them and know how to appeal to them. Now, the problem is, I think, a couple. One, the pool of arbitrators is expanding. Proxies are no longer sufficient. And as arbitration has grown, telephone calls, personal research is no longer as sufficient. So what is, I think, becoming increasingly important is for parties to be able to identify and reference the track record of arbitrators' past decision-making in a way to understand what their proclivities, what their experience, how that might translate into decision-making that they can then appeal to, as Mark said, through advocacy. The problem is arbitration information about arbitrators' past decision-making is like an iceberg. The number of redacted published opinions awards in international arbitration is tippy top of a very big iceberg. And in fact, that's why we call around, because those decisions, even if it's increasing, are not nearly enough. So what arbitrator intelligence tries to do is it is what you might call like sonar. It seeks to go, and we've had the water metaphor once before, it seeks to see and identify what is below the water. What are some of the patterns, in particular arbitrators' decision-making, that might help counsel and parties understand if this is an arbitrator they want to choose, or if they're preparing for the hearing, how they might frame their advocacy for that. Now, to do that, I think you need information on a lot of different topics, not all of which are in awards. So, for example, one of the most important topics parties research on is document production, because they either want and need document production to be able to prove their case, or they oftentimes want to avoid document production for efficiency or other reasons. They want to know how what the decision-making on other types of procedures, on other types of substance are. I do think in the future, we've been looking for many years, how do you balance increasing transparency, empowering parties to make more informed decisions about arbitrators they're choosing, and to make counsel have a better informed understanding of how to know their audience, how to present to those arbitrators. On the one hand, so parties crave and need this kind of transparency, but at the same time, they want the big part of the iceberg to remain under the water. We are not at a point where confidentiality is something we're willing to sacrifice for the needs. So what we do again at Arbitrator Intelligence is try to create the data analytics that provides a sort of balance between the transparency that's needed and the confidentiality that's required. The way we do it is we collect at the end end of each case. We do not ask the parties' names. We don't ask what the legal issues were, or what the procedural issues were, or what the factual issues. We only ask for the decision-making, kind of the outputs, so that we can then compare them. Going back to the comments that were made by Teresa earlier about the tribunal's decision-making, if you have a dissenting arbitrator, which is very, very unusual in commercial arbitration in particular, you can identify a particular outcome or decision with a particular arbitrator. But what data analytics allows you to do is, if you see patterns of decision-making, you see one arbitrator who, in the vast majority of cases in which this person has sat, they have more document production than another arbitrator. You can't attribute that decision necessarily to that one arbitrator, but you might think that you have a better chance, or you're more likely to have, if you have this arbitrator on a tribunal, a chance to argue in favor of that, or if you want to avoid it. So data analytics will never essentially open the arbitrator's mind and describe to you in detail what their cognitive biases are, their decision-making preferences, their psychological drivers. But it can give you hints that are extremely important when, as an advocate, you need to know your audience, when, as a party, you want to know who to pick as an arbitrator. Thank you.
Thank you, Catherine. That was really interesting. I don't know if Teresa and Mark have something to add, because it's very, very specific topic.
Mark first. Diversity.
Yeah. No, I mean, arbitrator intelligence is a very interesting topic. I must say that I am cautious about it because, as I said, my fear is to have the positivist model integrated in arbitration, and it is not what I want for arbitration. It is, for me, in fact, arbitrator intelligence, what, if I understand well, could permit to associate a certain type of decision to a man, to a woman, and to an arbitrator. And and in fact, for me, it's not what arbitration should tend, because arbitration for me is is the classic way to render justice, in the Greek way, which means that justice is rendered out of the dialogue, which means that each time you have a deliberation, you start from zero. And I don't want to have taking the model of what state justice is. And that's why I think it may be a very interesting tool, but I think that we must be cautious, because, as I said, I don't want to have arbitration losing its soul, because of that, because of this dialogue aspect. That's my observation. Very general.
So, can I offer just a quick clarification?
Yeah, please.
Maybe if I can clarify, and maybe it also perhaps addresses at least what you wanted to say, Teresa. So I do think, one of the, just to clarify, what is sometimes a common misunderstanding, and there are people who are working to do this, but arbitrator intelligence does not seek predictive analytics. So predictive analytics is when you ascribe to future behavior. You say, well, we think the outcome in this arbitration is more likely to be X than Y if you choose this arbitrator. Some of that's done with jury selection in the United States. In the United States and in some other jurisdictions, there is a great deal of what's called predictive analytics. It's a process of taking all the different sources of information about past decision making and trying to predict what will be done in the future. I don't think in international arbitration, even with the information that arbitrator intelligence is bringing together, that it's really anytime possible in the near future to do responsible predictive analytics. And I think if you can't do it responsibly, you should not do it. I do think, though, what we do is much more like is much more akin to the kind of phone calls that are currently going on. So we're not doing anything that doesn't already exist. We are just collecting it more systematically and making it available to everyone. Because right now, how you collect the kinds of information we collect is by phone calls, which may work very well if you are a big law firm with a huge network of people to call. Okay, but that's not how we should determine who has information and who's not, right? Especially as we're seeing, and this is particularly relevant in an arbitration event seated in Ukraine, we are seeing some amazing regional law firms taking on very big cases. And they shouldn't be at an informational disadvantage because they have a smaller network to research through. And so what we do is we collect the same kinds of information, again, just more systematically, and making it available to everyone equally, as opposed to based on personal relationships. Not that there aren't risks, and not that there aren't challenges. I have always understood this because it started as a research project. And as you know, my area of research is ethics. So I've always thought we need to be very careful about this. But I don't think those risks distort the process. So that was the one clarification I wanted to add.
Thank you. Teresa,
if I may, I have rather questions. Obviously, I am aware of Catherine research and so challenging and interesting, and I always wondered how she could manage in such a world where, for instance, you said something, and it is a question for you. I always wondered when trying to follow I have read most of what you have written, in particular on ethics, but on arbitrator intelligence, as you just explained, you said, correct me if I'm wrong, identify arbitrators' past decision making, correct? And at the same time, you say, quite rightly so in my view, that it's very difficult when we have a three-member tribunals to attribute to one or the other of the arbitrator the prevailing view that at the end is the subject matter of the award. So I think it's very, very difficult. And at the same time, I remember having chosen, selected and recommended to one of my clients an arbitrator for what he had written on the legal issue at stake, and he decided exactly the opposite in the award. But true it is that there were three. So, and when you mention, Mark and you, the issue of dissenting, I mean, most of the dissent you don't see. What you can see is what I mentioned. You have a full liability recognition in the award, and you have a damage claim which is 10% of what was asked without real explanation. And it is the result of what I said, the bargaining. I would like to put an end note, because I would like not to take the time to the participants and to other people. But what I would like also to say is that I was not mentioning, I am not talking, I fully agree with the fact that biases might not be the right word, because it has a sort of connotation of misconduct, which I thought set aside in saying that it is not the more interesting of the bias. It's rather the question of cognition, of different cognition, or I don't remember the exact name you use, but bias has a negative sound, which I must say not only doesn't interest me so much, but in addition is not the main one. I never or almost never met this kind of bias. Conversely, I met this kind of bias. I mentioned that one of the arbitrators considers himself or herself as having been appointed to defend the thesis of the party having appointed him or her, and arguing the case in the tribunal with it, which is very difficult. And at the end, the result is what I said, is a sort of compromise, while the tribunal is not called to decide ex aequo in bono, but rather under a certain set of laws or rules. Well, thank you for your attention. That's what I wanted to. But it's a very interesting panel. I would like to have a full day on these subjects with Olena as moderator, but also as speaker, because these are so important and so sensitive issues, and I can see that all of us are quite concerned Olena, I must say your selection, at least for the other two, was perfect.
Thank you. Thank you, Teresa. So I have just received a message from Justice Pilkov. Unfortunately, his hearing is still going on and will continue tomorrow. So he asked to beg the pardon and apologize for his inability to join our discussion. However, we have some more time. And we have time for questions. We have received several questions from the audience, and the first question comes from Yanina Vlasenko from Spain. Do you think that it is better for an arbitration lawyer to have some additional education in management in order to improve the decision making? So, additional education in management. I would add that probably something else, but let's start with management. Yeah. Do you think the additional education would be helpful?
Additional education is always helpful in any case, but I'm not sure to understand what means management in that context. Maybe she can explain.
Some business school, you know.
So, like you did it, Mark? Did you?
No,
you
no,
have
I
a
didn't.
business sort of.
I have a in economics and law, but
economy, yeah.
Well, it's not bad to have it. I would say it certainly can serve, but I don't think it's absolute. I don't think it is necessary for sure. But of course, I mean, we have more and more double, double masters. So and MBA plus a master in law. So yes, I mean, of course, it's good. I mean, it can be, but it's absolutely not necessary. I know, frankly, many of the most well-known corporate lawyers in Paris do not have an MBA or have a business school, so it's not necessary.
I might add one point of view that I agree it's not necessary, but maybe this is what the person who asked the question was getting at. One thing that when they have surveyed in the United States, at least general counsel, not in arbitration, and really just a general survey of general counsel, and they said, what is the quality you want in a lawyer? And when I hear this, who educates, a range of ideas in my mind. But the one thing they said that was most important is they want a lawyer who understands their business. And that was not anywhere on my list. But I do think that clients, parties want someone who understands their business. So I guess that might be one way to interpret the question is, would business school perhaps help you understand at a deeper level the actual business transactions underlying the dispute in a way that might be appealing to the parties? So I don't know if that's necessarily what was being asked, but as lawyers, sometimes we do forget, the business interests of the parties, which of course is part of, why they go to arbitration. So I don't know if you need a degree to do that, but I would say it's certainly the business side is important for the parties in choosing probably an arbitrator.
Thank you. Yeah, Mark?
Yeah, no, sorry, I fully agree with Catherine. Like, you need to be business-minded to be a good arbitrator. I think you need to understand business.
If I may, I would add economy.
Yeah, economy. It's more global. You are right. It's more global. It's in business. And that what we don't have. Well, that sometimes it lacks in before state justice, judges. So, well, it's good to have to be economically minded.
Okay, thank you. We have also several questions from Vitaly Kravchenko. I will take the liberty to pick up one in the interest of time. It's a question to Mark, but probably Teresa and Catherine would like to join. What do you suggest for a counsel to oh no, not that one. Do you have any suggestions for the counsel in terms of strategy when there is a reason to believe that an arbitrator is biased?
Well, what would be the strategy for a counsel?
If I may, while Mark is thinking, may I, Mark? I think I would exactly advise what I have mentioned in my short intervention, is that if I am faced with this kind of perception, I would ask for a listing of I would use the tools I mentioned and say the parties, my client would be interested in discussing the issues to be decided and to share the sort of decision tree with the parties, so that I would use these kind of tools to limit the damage that can create within the deliberations of the tribunal. So that's what I would do, and I actually did. Candidly, saying not looking at all, being aware of what is going on, but it's quite easy to identify the unexperienced bias arbitrator. It's more difficult for the experienced bias arbitrator.
Okay.
Yeah.
But Mark, sorry, I took the floor. It was your turn.
It's interesting. I'm not sure I have a very, frankly, a tool. If I understand that one of the arbitrators is biased, well, I think I will ignore it and I will concentrate on the president to try to convince him. I will. It's difficult, you cannot ignore him completely, so you must do with it. I'm not sure there is. Of course, again, there is what Teresa proposed, which is interesting, but otherwise, I will very much on the president.
Okay, another question from Vitali concerns the useful sources of literature. So what do you suggest for a counsel to read in order to learn how to influence an arbitration panel? So any reference?
Catherine is a specialist, but there are several very good books in the US about advocacy, the art of advocacy, and articles about the various psychological biases, drivers, etc., etc. So, but there are some books, and I think there is something like the art of advocacy. But Catherine, you may know.
So there are great. I don't teach advocacy except in the context of the VSU, so I'm not comment on the articles, but I guess, and a bit cheeky, and I apologize for the shameless plug, but I think you should read our reports, which I think will tell you, they won't tell you how the arbitrator is going to rule, but they'll tell you how in more cases than you could collect by phone calls. And I think this goes back a little bit to Teresa's point that it's not that that you can say, okay, well, I know this arbitrator's been in 5 cases. I'm going to, in a sense, assume away the merits of this case. Of course, every decision is influenced both by their co-arbitrators and the merits of the case. But at the same time, if you see a much higher proclivity among tribunals on which an arbitrator has sat to do one thing instead of the other, it seems to me that would be a very relevant thing to read as an advocate, to understand where some of the kind of soft spots might be, where there might be room to leverage or maximize your ability to affect sort of the outcome or the decision making on the tribunal. But I really think that's a great topic, great questions. But I think it's really a whole Mark. I know he does give a whole course on this, and I think it's hard to probably say in just a few words, kind of what the best techniques or the best readings on that are. Mark, you probably have written some things on this that you should recommend.
Excuse me?
I said you've done things on this that you should be recommending.
Yeah. In fact, you have this Nobel Prize, which is not exactly on advocacy, but more on the psychological drivers and how which is very interesting. It's a book which is very well known in the US. I don't remember the name exactly. I was looking for it.
It's called the Kahneman is the name of the Nobel Prize winner, and it's Fast Thinking, Slow Thinking. And then a subtitle, I don't know.
Yes, okay.
This is quite famous book.
Yeah,
and
it's very interesting.
Yeah. So the time is flying, and with this, we need to conclude our session. So I would like to thank you all for your very interesting presentation and comments, very insightful, very thought provocative. I hope our participants have enjoyed our session, so thank you very much. I also need to make a small announcement with regard to further part of the conference. So now we will have a network session. For networks, there is a separate Zoom link. You have probably received it at the email for confirmation. With confirmation of your registration, it's also available at the website of Ukrainian Arbitration Association. So once you enter the Zoom, you will see 7 different tables with 7 different topics assigned to each or table or virtual room, whatever you call it. You could choose anyone. It's not the same room the entire evening, so you can then change the room if you wish. In case of any issues, again, you could contact technical support according to by the email indicated in the link. And so the format is very like free discussion, exchange of ideas, sharing experience. So you could either listen or you could take the floor and say something about the topic, or to say hello to our participants, or whatever you choose. So please join our networking session and stay with us. See you tomorrow and today on the network session as well. Thank you.